देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा। मैं कंजूस पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा। ये कानून आ गया, अब अगली दफा कोई केस लिया आएगा हम वो वाला भी देख लेंगे। मैं ओपिनियंस कभी नहीं दूंगा। आप हमारे या तो एडवाइजरी जुरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे। आपका काम है अपनी सरकार, अपनी गवर्नमेंट को ओपिनियन देना, हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म। हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा। भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे। बहुत सारी चीजें आप कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत। हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है। मेरी तो मुझे तकलीफ हो रही है। सुबह से 57,600 कोई 57,000 है, अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़। आप चला लें एक महीना केस, हमें क्या फर्क पड़ता है। फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब आवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म। ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट नंबर 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे। आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है। मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है। अलग बात है आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें कानून को, ये तर्क कर दें। मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे। कोई इख्तिलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है। हमें आपको परसुएट करने की कोई जरूरत नहीं, आप हमें परसुएट कर लीजिए। और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला।
My lord, my learned friend is questions.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
my lord,
I'm not engaging in theoretical argument.
my lord.
I'm trying to understand the basis on which you are defending the
My lord,
constitutionality of this law.
आपका सवाल.
So therefore my question stands. Tomorrow if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity, that is within Parliament's competence?
My lord, if that is so,
Learned
and if it
Attorney
so
General.
happens,
Yes,
Learned
not
Attorney
conjecture.
General.
This is to
Learned
establish the
Attorney
principle.
General.
You accept
Learned
that?
Attorney
Absolutely,
General.
my lord. Absolutely.
Learned
it is in
Attorney
Parliament's competence. And if I may say so, my lord, my lord, I have
provided assistance.
I have you know, as Attorney General. Ji, absolutely. Yes.
Mr. AG, to your right. Section 2 may it provided that the bench, constitution of the bench. Suppose bench is constituted. Who will assign the cases to the benches? Still this power has not been given in this act. Again, there will
My
be...
lord, the committee determine its procedure, and then it, with regards to how the meetings are to be, the committee itself.
Who will assign the cases that this case will be fixed before this bench? And one thing more, if 2 members, senior members comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta registry for 1 month, for 6 months, or for 1 year. Is it possible?
My lord,
What will we do if this situation occurs?
My lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, which would have included when and how the meetings were to be held and the constitution of benches, etc. But that never happened because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so with regret, was a first. My lord, this is exactly what under subsection 2 the committee is to do as the first.
We will regulate through rules. They will regulate this act through rules.
My lord, the committee will determine its procedure by the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their relevance, what their status is, an SRO, as a rule, or whatever they call it, but the committee can determine its procedure, and it will be a procedure of the committee for the purpose of its functioning. Now, section 3, my lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and which was asked when the petitioners were arguing that the committee is to first see whether the matter is, it has to come before the committee to determine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo motu powers either, because while exercising suo motu powers, it is either previously it was the Chief Justice who first determined whether the matter was of public importance and relatable to enforcement of fundamental rights, and then constitute a bench. This is this tension which my lord had also while authoring rendering judgment.
This doesn't answer the question whether the threshold of 184.3 is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that this doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?
My question is, there's a distinction between what is filed under 184 and that's why, my lord.
My question is, if the Chief Justice, just one person, as a master of the roster, could decide whether to take a suo motu or not, why not a committee?
Yes, and that is why my response was that
further if providing guarantees, and my only question is, are we not accountable to the litigants?
Absolutely.
The Parliament is the representative of the litigants. If they want to change our procedure because they are not satisfied with our internal or institutional independence, that's their prerogative. And we are there to serve the litigants.
And if I may, my lord.
Normally, you see, the cases would be marked by the Chief Justice, even if it's a 184.3. So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question is, earlier the Chief Justice would mark the case to somebody. He would certainly mark it. I mean, I as a judge would not hear any case unless it's marked to me. And then all it says is that instead of the Chief Justice, the committee marks it.
Section
Judicial power is not in any way impeded, because judicial power comes after the bench.
Section 3 talks about invoking of jurisdiction, and that is what I was addressing.